Good afternoon. It's me, Tracy B, for Thick of It Thursday. Um, I am, I've been for the last couple of weeks been talking about custody agreements slash parenting plans. Um, as I mentioned before, they can be referred to as so many things. Custody stipulations, custody orders, custody, whatever. It's all the same. If they address custody, decision making, visitation, access, all that stuff. That's what it is. It's a custody agreement or parenting plan. Depending on where you are, will determine the language used, but they all cover the same basis, and that is access and visits and custody of kids of married parents, unmarried parents, doesn't matter. There's no distinction as far as that's concerned. The distinction is where you are, your jurisdiction. So, as I mentioned last week, I wanted to actually show you guys a, a parenting plan. Now, this parenting plan that I chose is from a jurisdiction that has its own. Not every state does that. Not every state has an actual form that they allow the litigants to use when it comes to visitation, custody, and access. But this particular state, which is Illinois, I believe, it does. It has a form. I think I mentioned last week or the week before how some places, when you file for custody or divorce, where there's custody is an issue or a modification, they ask you to automatically complete their form, their parenting plan to submit with the whatever application you're making. So, and this is one of them. This is one of those states that do that. So, this is a parenting plan from, I'm hoping I do this right. Let me just see. From the state of Illinois, as I mentioned, trying to figure out how I actually go through the pages because I think this is it. No, is this it? Yes, this is it. So I'm hoping you guys could see this still. Okay, yeah, you don't need to see my face. You need to see this. So, as it says, parenting plan. So, this parenting plan was submitted by the respondent. The respondent is the defendant, respondent. I think those are usually the two words used. Um, this is what the respondent is proposing. So, I'm assuming the respondent is the one that made the application or not. It could have been the petitioner's application, but for some reason, the respondent is submitting a parenting plan. Usually, if a respondent or defendant is submitting a parenting plan, it's because they've made an application for modification of a previous plan. So, um, sorry about that. So, they always cover some basic background information, the background information for both parents, employment, um, the kids' names, date of birth, who they live with. And here we're starting to get into the substance now. So as you can see here, it says health decisions. Health decisions is definitely something that will more than likely, never mind whether the state has its form or you're creating one. Health decisions is definitely something that has to be addressed in parenting plans, custody agreements. They have to be because that's a major area for parents when it comes to raising their child. And a lot of times, parents don't agree about health decisions, believe it or not. It could be something that we take for granted, um, but it's definitely something that uh, a lot of parents disagree on, and so it's a major issue. Hold on 1 second. Sorry. Um, religion. Some people, religion is a very, very, very important topic to address because some people some people, some families have a difference of religion. Like mom could be, Muslim, and dad is Christian, or something like that. Um, Sorry, I'm getting a phone call and they keep calling, and I'm trying to tell them to stop calling me. So it should be addressed. That should be addressed, because believe it or not, when it comes to celebrating religious holidays, that can be disastrous if you don't address how the holidays, religious holidays, are to be split, allocated, divided, whatever. It should definitely be. I don't like to use that reserved, that this reserved. Um, no, I'd rather address it. So if, for instance, petitioner, plaintiff, is big on Easter, but respondent is not, and Easter falls on respondent's regular weekend, what do you do? Does petitioner get the Easter anyway? Does that Easter trump respondent or defendant's weekend? Well, you need to address that. It needs to be addressed, because that, if it's important for either party to spend a religious holiday with the kids, it should be addressed. It should certainly be mentioned in the agreement. Extracurricular and recreational activities decisions will be made. Again, that falls in line with the legal decision making, with respect to medical, school activities. This is up there with that. So who's going to decide? And if one parent gets to decide, and there's still if one parent gets to decide, then there's no problem. But if you say both parents, if both parents are chosen and they disagree, how are you going to resolve that? One parent needs to have the final decision making. So I certainly always include that. If you choose both parents, it's kind of counterintuitive, because who is going to be the tiebreaker? Who's going to decide when the both parents are at an impasse? That that should be covered. Parenting time. Now, parenting time, I mentioned, I don't know if I mentioned, I'm assuming I mentioned, but parenting time usually is something, um, that the schedule is usually something that most jurisdictions have they have a pattern, they have a baseline, they have a skeleton to work with. And it's usually, based on age, based on distance, based on, uh, prior contact that the non-custodial parent had with the child. There's a lot of factors, but there's usually some sort of skeleton or baseline to work with. And what I mean by that is, like, for instance, I was just talking to one of my clients, and he was telling me he was negotiating a visitation schedule with his daughter's mother, and they were having a disagreement about the number of days during the week that he should be able to spend with his child when it's not his weekend. And I had to explain to him that in his particular state, what she's proposing is usually what it is. That's usually the schedule that's usually recommended by the courts. Um, he didn't want to agree to that because he's been having more. But I explained to him that when it gets to the point where the court has to intervene and help decide, if they have to decide, they usually have a baseline. Now, you can do more or even less depending on other factors, but they usually have some idea of what they usually have a set pattern or a set schedule that applies to, again, like I said, depending on the age of the kids, the number of the kids, the uh, the degree or the depth of access the non-custodial parent had prior, amongst other things. And that's what this all covers: uh, day to day, weekend, holidays. Um, Holiday schedule is usually something to, as you can see here, in even numbered years, petitioners shall have children on Group A holidays, and respondents shall have the children on Group B holidays. That's pretty customary as well. One thing I've been seeing from a lot of people in the different groups that I am the administrator for or the co-administrator for is people deviating from this and sort of working out their own schedule when it comes to holidays. Now, as a GAL, when I was a GAL, I used to split the holidays. I used to recommend splitting the holidays. So if one parent gets Thanksgiving Day one year, then they get Christmas Eve that same year. They don't get Thanksgiving Day and Christmas Day. But if the parties agree to that, then that's on them. They could do that. So again, that's an example again of the skeleton or the basic outline that most jurisdictions will have. But anytime you can agree to something, of course, most courts will be amenable to that, unless, again, and I'm always going to stress this, unless it violates or it goes against public policy. So, spring break, summer break, those are always, always, always included. They should always be included as well. Some kids, I think, get like a winter break. What do they call it? Winter break, something in the middle, and then spring break. I don't remember because my son is homeschooling now, but I think it was something. I know there was like 3 major breaks that kids get now. When I was a kid, we only got 2, but now it's a thing where they get like 3-week-long breaks. So yeah, if that's you, then yeah, you should include that as well. See, this is what I was talking about. See how this says conflict? If there's a conflict, the priority will be. That's the language you can use back in that decision making when it comes to anything, extracurricular activities, medical. If there's a conflict, the priority will be, or the decision will be made by respondent or petitioner. That's how that language would reflect. Transportation of the kids. Now, this is something I mentioned last week where this becomes an issue a lot, especially when either parent starts dating, because they sometimes believe that when the other parent comes to pick up the kids, that no one should be accompanying them. And, for whatever reason, I understand. The thing is, though, is a matter of, logistics or a matter of covering your behind. Sometimes you want an extra or a third person to accompany either parent to be a witness or to diffuse things or whatever. Now, from my experience, depending on how that person adds to the dissension of the transportation or the pickup and drop off, a judge may or may not order either way, if that makes any sense. So a judge may say, listen, Mary, I'm not going to order Peter to pick up and drop off on his own or to not send somebody else if it's a matter of, convenience or scheduling or whatever it is. Because if that person is not creating more of a problem for your kids, then I'm not going to do that, because that means that he'll be deprived of his visits, and I'm not going to do that. And vice versa. I always say, I always use, the mom in a certain predicament and the certain position, and dad in a certain position. It's not because I favor either one. It's just because it's always easier. I just always default to women in certain positions and dad in other positions, but they're not mutually exclusive. So, electronic communication. As I mentioned before last week or the week before, and I'm just going to keep saying last week because I don't know. That should definitely be included. That should definitely be included because, again, believe it or not, electronic communication sometimes create so many more problems than necessary. And however you address it, it should be addressed. Okay. This language, electronic communication between the children and the other parent, must be unreasonably monitored or interrupted. must not be unreasonably monitored or interrupted. Now, depending on the background of the case, this might need to be a little bit more explicit. You know, the child is to get 15 minutes unaccompanied time in a separate room where dad or mom or anybody else is not present, something like that. Again, it depends on the background of the case. I would definitely probably add some additional language in here if that's been an issue before, or if my client or either party stressed how it's been an issue before. We would definitely get more explicit with the details here. And we would say, we would actually determine which means of communication would be acceptable, because some parents don't allow the use of a telephone when the kids are in there, when they have their visiting time with the kid or access with the kid. Email may not be feasible. Text, same thing for, same reason for telephone and even video. So we would actually get very, very detailed about which mode is going to be used. Hold on, I don't know what I just did. So exchange of children, we just mentioned that briefly. Drop off and pick off would be at, whomever's home or whatever the location. Here it is, drop off and pick off of the children that will take place at blah, blah, blah. Now, something came up with the case of mine regarding pickup and drop off at either a public place or precinct. Some police precincts have really nice facilities just for pickup and drop off. It depends on where you are. And so they do that so that the kids don't know that they're actually at a police precinct, and not traumatized by the presence of, cops being there. Some agencies do that. Some agencies who do supervised visits, some agencies who don't necessarily do supervised visits, but they have a little area, a section just for pickup and drop off. And these are usually in instances where there's a history of domestic violence or abuse, or just any sort of conflict or dissension that rises to the level of, pickup and drop off just not going smoothly. So if you're not comfortable with either parent showing up at the home of the other parent, then you can explore those possibilities as well. Excuse me. First refusal for childcare. This again, I don't always include this. A lot of times I'll just check this. There's no right of first refusal. However, it's because, and I have a reason why. Sometimes, again, with logistics, it makes things so much. And let me back up. I'm of the belief that sometimes some things just don't need to be that detailed, because all it does is it creates more of a problem. So sometimes, okay, let's use this as an example. First refusal for childcare. Each parent must offer the other a first right of refusal as follows. Sometimes it's not feasible to offer that parent. Sometimes emergencies happen and you don't have the opportunity or the chance to notify and wait for a response from the other parent. So what are you supposed to do? Do you go ahead and make, other arrangements anyway? And when you do, are you in violation of the agreement if it explicitly states this is what you're supposed to do? You know what I'm saying? It's a catch-22. So a lot of times, depending on, again, everything is about the background of the case. Every single case is different. I don't care how much somebody says your case sounds like mine, is exactly like mine. It's not. It's not. Your facts are different. The parties are different. The judge is different. The GAL is different. Your jurisdiction is different. Everything is different. Everything is different. And so it depends. It depends. And most of my followers know that for me, everything is about strategy. Everything is strategic to me. So I'm always thinking 10 steps ahead. I'm always thinking of minimizing creating an issue for my client. I don't want my client to be held into court for every little thing. First of all, it's time consuming, it's stressful, and then it's expensive. So sometimes when I suggest to leave some things out of an agreement, that's why. Because sometimes it creates more of a problem than a solution. So, and not only that, strategically speaking, it just doesn't serve any purpose. So, but I see so many people now, they want that first right of first refusal, whatever, however they call it, they want that there. Um, yeah, but I'll read it. If a parent needs childcare for a period of 24 hours or more during their time with the children, they must give the other parent the option to care for the children before finding other childcare. As soon as the need for childcare is known, the other parent must be immediately notified. Okay, and suppose you do that and there's no answer. The parent offered the right to care for the children must accept the offer within 2 hours. But suppose they were in somewhere where it wasn't their fault that they couldn't respond. They were in somewhere where they had a dead zone. Like, where does this end? Otherwise, the parent needing childcare may use another caregiver. Transportation of the children is the same as for other parenting time. So you see what I mean? How that can create all kinds of problems. Yeah, it covers a lot, but it can also create a lot of problems there, logistically, practically speaking. So communication. A parent who does not have the children in their care may have electronic communication with the children anytime. No, I wouldn't choose anytime. I would say we would have a window. It's best to have a window because the other parent can start to interfere with that parent's time. And if you're the non-custodial and you're getting alternate weekends and that's all you have time for, you don't want your alternate weekend times to be interrupted by the custodial parents' constant calling or texting or video chatting. It's unfair. It's unfair. So I would seldom use any time unless the parties agree to any time. That's fine. Um, my son's dad and I, we had no set time. He could call him anytime he wanted to because it didn't create a problem for me or him. Um, this is a big one. State the date and parent plans to relocate. That's a bigger issue, and I wouldn't. I've seldom addressed this in a parenting plan, like limited. It would get really, really, really detailed. Well, I should back up. It would get really detailed if that was the plan to begin with, if that was an issue to begin with, if that was a desire or a goal. And some people do know that once their divorce or custody case is resolved, that they would like to relocate back to their hometown, home state, somewhere cheaper, for a number of reasons. So, but if that's the case, then okay, so here we go. This is paragraph 10, relocation of minor children. If a parent with the majority of the parenting time or equal parenting time wishes to relocate with the children, they must have the agreement of the other parent or permission from the court when. And this is, this one actually gets into a lot. The children's primary residence is Cook County, blah, blah, blah. Children's primary residence in any county. The move is outside of Illinois, more than 25 miles. The parent asking to relocate with the children must provide within written notice. Yeah, this is it. This is pretty standard language, actually. This is pretty standard language. So, again, if there's a plan to move beyond that, then we would really get detailed about that because co-parenting long distance changes the rest of the parenting plan, the rest of the custody agreement. So that actually looks a little different than this one that I'm using right now. The parents agree on the move and no changes needed to the parenting time schedule. Both parents shall sign the notices. Followed by, if the other parent agrees with the move but changes need to be made, and the parents are in agreement about the changes to the parenting time schedule, the moving parent must have the other parent sign the notice provided about the move, file the signed notice with the court, and file an updated parenting plan with the court. This varies. This varies. Again, this is a state developed form that I'm going over. So this is something, and this particular state allows for amended plans to be submitted without without a petition or open petition, open case pending. Not all states do that. To submit an updated parenting plan or agreement, either party has to file a modification and submit it that way so that the judge can so order it. Again, that depends on your jurisdiction, though. And this is very, you know what, I would really like to spend more time on the relocation aspect because that is very, very, that's actually a topic that comes up a lot, but it's very, what do you call it? Esoteric. It's very esoteric. So it's something that needs to be really some time spent on it, which I will do a relocation video really soon because I get questions about that a lot. So designation of children's custody and residence for other purposes, because you cannot predetermine jurisdiction. That is not your right. That is the court's obligation. That's the court's duty. That's the court's responsibility and authority. You can't say, I want Illinois Cook County to maintain jurisdiction of the children when they've been living in Texas for 3 years. You know, it doesn't work that way. Okay. This is something, resolving disagreements. This is something that I don't see a lot of people bringing up often, but it should, because there are other ways of resolving disagreements of a custody arrangement and parenting plans than by filing a modification or a contempt petition and going back to court. You can use mediation. You can use a parent coordinator. You can have a therapist determine that. There's so many other less expensive, less stressful, less intrusive ways to resolve disagreements. And I think that more people should take advantage of that. I really believe that this should be included in a lot of agreements, and it should be something that parents take advantage of. I think it's something that, we should really consider. Mediation it works. It does work. I mean, you have to get, just like there's good and bad lawyers, there's good and bad mediators and good and bad GALs. But people should definitely take more advantage of that. Mediation, like I said, parent coordinators. There's another word for parent coordinators. Parent moderators. Therapists sometimes step in that position. Supervisors, people who supervise visits, they can do that. It depends on your jurisdiction. Changes to the parenting plan. Again, some courts require changes to the parenting plan to be submitted. You can submit it like this court does, where you just submit it. Some of them require that you file a modification and you get the court to review it first. Even if it's a mediated agreement with changes. It depends. It depends. Okay. Is that it? Yeah. So that's it pretty much. I'm looking to see if anybody has any questions. Hold on a second. Right now, anybody have any questions? Again, this is just one example. I know. Sorry, my son. They vary. They vary. I actually, as at the divorce solutionist, one of the things I do is I help people customize their custody agreement or a custody stipulation or parenting plan based on the particular circumstances, the background, all of those things of their case, their jurisdiction, the judge, the rules of the local procedures and rules, case law, those kind of things. Like I do, again, it's about strategically coming up with something that's going to be advantageous to my particular client. But that's something that I definitely do. I don't think, I see there's a lot of websites that allow you to develop parenting plans and custody agreements. Um, and they're good as a starting point, but you still want to have someone help you go through those so that you understand what the provisions mean and the ramifications or the consequences or the possible outcomes of not following, not understanding, not adhering to a particular provision. They're not, they're not something to be taken lightly. It can, if you do it incorrectly, or if you do it haphazardly or in haste, you can wind up setting yourself up for um, more litigation, more stress, more money, et cetera, et cetera, et cetera. So if that's what you want, you can reach out to me. I'm actually um, working on creating, I do a strategic action plan for divorces, but I'm actually working on coming up with one for custody as well, because it's a little different. But if you're interested in that, please feel free to reach out to me on the divorcesolutionist.com. I do free 15-minute consultations. So to discuss how my services, any one of my services can help you. So feel free to go to my website for that, or just go directly to Facebook DM and ask me, and I'll send you the link to schedule a call. But or join my group, the Divorce Glow Up, or the Pro Se Divorce and Custody. They're both on Facebook. Follow me on Facebook at the Divorce Solutionist, Instagram, the Divorce Solutionist, Twitter, the Divorce Solutionist, LinkedIn, the Divorce Solutionist. I got a YouTube channel, the Divorce Solutionist, the Divorce Solutionist. It's all the same, it's all consistent. I have a myriad of services that can help you in whatever it is you have, divorce or custody, no matter where you are in your case, no matter whether you're represented or not. There's something for everyone. So anyway, since I have no questions, I'm going to end it there. Feel free to, if you do have questions, to post them on either one of the posts, and I will certainly respond to you as soon as I get them. Until next week, thank you for tuning in, and I look forward to seeing, speaking, chatting with you in the future. Bye.